Any mention?
Yeah, please, Your Lordship. I beg to mention item number 20.
Item number?
20.
Come here, tell me.
I humbly pray let this matter may come after 2 weeks, Your Lordship.
Why?
Because the conducting counsel is having
Who's going to
personal...
counsel?
Shri S. De.
Shri S. D?
Yes, Your Lordship.
What's the matter about?
No, Your Lordship.
Okay, 2 weeks, yes. Yes.
I do oblige, Your Lordship.
Please receive. I beg item number 19. Your Lordship.
Who's for the other side? Mr. Sen, you're there. 19, Maya. What's the matter about?
Relaxation of age, Your Lordship. Relaxation of age.
Which item?
19.
This one, official.
No.
Why you want adjournment?
Your Lordship, I have received instruction from my client, Your Lordship, that the government has passed a notification, but it's yet to be issued, Your Lordship.
This is matter, post matter after 2 weeks to enable Mr. Dinyota to obtain further instructions. Yes.
All right, Your Lordship.
Yes.
Lords, I am mentioning item 21. It's an election petition.
Yes.
Lords, both sides are before an arbitration tribunal which is conducting cross-examination in Shillong. So
You are there, the matter, correct? No.
yes. I am.
Then you put an adjournment application if you want adjournment.
Okay. I am making a similar prayer for items 4 and 5.
4 and 5, my lord, I have a little bit of objection because issue session has already been submitted. Because only there are only
matter will be called out. Yes. Regarding 21, you put an adjournment application.
Obliged.
Should I beg to mention item 25?
Yes.
Item 25.
Number?
25. Mr. Chanda is not available.
What's happened to Chanda? Is not well.
Lordship, his wife is in a critical condition.
Oh. After 2 weeks, yes.
File your Lordship.
Much obliged. Supplementary list, item number 1.
Excuse me, Lordship.
Yes.
This file has just been
You've
endorsed
seen
to
the
me.
case.
Just endorsed to me, this file, my lords. May I pray this matter comes on
This
Friday?
is very unfortunate if this is
Lordship,
happening.
very serious issue. May I pray that this matter
Mr.
be listed
Shilla,
on
what is your
Friday?
village doing?
Lordship,
We called them here.
I'm respondent number 5, Lordship.
You're the village.
Yes, Lordship.
You're the person who's
No,
doing
no.
all the injustices to the petitioner.
No,
Who was the person then?
it seems that
You know who they are.
the name of one private individual.
What is?
But Your Lordship, kindly permit us to file show cause because
No, should.
because
See, if what he says correct, out here there's no private persons. Only number 5, the Darbar Shillong Mamulu 2. Does you correct?
no in the FIR, Your Lordship. If you have FIR, Your Lordship will see they have filed in the FIR.
You take down this miss case number 26, 2024, in WPC number 173, 2023. The petitioner, by the instant business application, has again brought notice of the court the situation. Brought notice of the court the when was the FIR filed, the last one?
On the 25th, 12th, 2023, Your Honor.
Nothing is done after that.
No, my lord. They have taken one person to custody, but in the midway, they have released this person again on the 30th.
Midway means on the way to the police station.
On the way to the police station. On the 30th, again, they have called that person before the police station. They have recorded the statement, but have not made any arrests.
The fact that the incidents of intimidation and what else? Intimidation and
the attempt to
threat to their life is still continuing. Stop. In this regard, Mr. Shongwan has submitted that an FIR was filed on 30th of
On 25th.
25th December.
December.
December 2023. But the police authorities have not proceeded the matter in right earnest, and that the instances of intimidation are still continuing, which has created a sense of fear and insecurity in the family of the petitioner. Stop. Mr. S.N., who's a senior government advocate, appearing for the state respondents 1 to 4, prays and to obtain instructions and to file a short affidavit. Similarly, is Mr. J. Shlapin number 5. So, next I expected that prompt action be taken. Otherwise, other orders will follow from this court. Yes. List after.
The main matter is coming on 29, my lord.
This matter on 29th. That's where the main matter is. You can. Otherwise, this can't go on. You can't. I had gone through, but I was wondering why you filed this case again. Yes.
Item number 2. Item number 2.
Yes.
My lord, they have filed a miscellaneous application for vacating the interim order. But I'm praying for 1 week time to file an
You file
objection.
by tomorrow, reply.
My lord, the main matter is listed on 5th of March, my lord. I'm praying, my lord, if this matter also can be listed on...
They are expressing some urgency, if it's correct.
My lord, Lordship, kindly see page 10, my lord, of the application, my lord. So many transfers are...
Of the?
Of the miss case, my lord. The last page.
Okay.
Assam Rifles 18 plus 1 plus 1, CRPF 20 plus 16, yes. BSF so many, my lord.
These are all GDMOs who joined and were given specialized while in service.
We indicated that also, my lord. In Assam Rifles, GDMOs with PG qualification 18, my lord. In CRPF 16, my lord. In BSF also 16. So, my lord,
one week time won't harm. We'll pass orders.
My lord, but they are not affected. I'm not asking for complete vacation of the interim order, my lord. It may apply
They will be
to
affected in the sense that you are in CRPF right now.
My lord.
You are being transferred to Assam Rifles.
Assam Rifles.
You don't want to be transferred to Assam Rifles.
My lord.
You want to stay at CRPF. And your tenure, your normal tenure is how much?
3 years, my lord. He's completed 5 years.
If
That also.
the policy is, if this interim orders are vacated, that means policy takes effect, then they'll be affected also.
My lord, what I submit, my lord, the status quo will remain as far as they are concerned, my lord.
My lord, on the next date, the entire matter can be heard, my lord, and disposed of.
Next case now 27 of 2024 in WBCM 329-23. This is an application for modification, alteration, clarification of and vacation of the order dated 5/10/2023 passed by this court in WBC number 329-23. Stop. MS Adata, this next line, please was allowed. Now allowed 4 days time to file reply. This dismisses application on next week is
26th.
On 26th, yes.
Item number 3.
For orders, yes.
Please, Your Lordship. Your Lordship, the legal aid counsel, Mr. Pubin, is hospitalized, so I kindly pray, Your Lordship.
Hospitalized? What happened to him?
He has diarrhea and fever, Your Lordship.
He's got?
Diarrhea and fever, Your Lordship. So I pray this matter come after 2 weeks, Your Lordship.
Records have come, Lord. Records were called for.
Yes, records. Officer indicates that the records have since been received. As Mr. Pubin is still indisposed, this is matter for 2 weeks. Yes.
Item number 4.
Please, Your Lordship, this matter was listed day before yesterday. Lords, and where we had proposed that a retired.
Yes.
Yes, this was listed day before yesterday.
Yes.
Where we had proposed that a retired engineer from the panel of MES, the respondent, may be appointed. The other side was to take instruction.
Yes, Dr. Mozika, you have any...
My lord, my instruction is that their application is under process, my lord. Within 10 days, we will appoint from the panel.
Other process in the meaning? How long have they put in the request for arbitration?
My lord, what happened? Because they are asking appointment from the panel of arbitrator notified by the ministry, my lord. So they have to sign one waiver agreement, my lord. I'll just place that, my lord.
Because courts not to look into, it's just to see whether it's arbitration clause or not. And if, then appoint arbitrator, that's all. Nothing else for a court.
My lord, in our submission, this application is premature, my lord. We are still under process. And what we ask them to is sign this section 12 waiver.
No, my lords. Let me explain, my lords. The clause suggests that they have the power to appoint the arbitrator. That clause is now inapplicable in view of the judgment in Perkins, my lords. Therefore, we have approached this honorable court.
Yes.
The waiver they want is to waive our right to approach this honorable court. We can't grant that waiver, my lords. That is the agreement that my learned friend is referring to. Because now the authority to appoint is not them in any case, my lords. Because
how are you saying they should sign this agreement? Arbitration Act.
They have no power to appoint, therefore waiting for them is, my lord, of no consequence.
There's a very recent judgment also, I think, last year, where all these judgments regarding Section 11.5, 11.6 have been digested.
But it was not a case of rejection, my lord. It's
so
not
even the question of stalling, the courts only look at whether it's only to see whether it's an arbitration clause. That's it. It's limited to that.
Well, we are not denying the arbitration clause.
Tribunals are best to. I mean, for the first preference to look into disputes. Is that a question of looking into other things?
They can't appoint. In fact, in law, they can't appoint. Only your lordship can appoint.
1 second. Why do you want waiver of this ability of 12.5?
Because, my lord,
by express agreement writing?
Because, my lord, Section 12 of the Arbitration Conciliation Act says, my lord, because if there is any kind of relation, my lord, because the list has been notified by the ministry, my lord, and most of them are the retired officers of the government.
Now you're saying that waiver of Section 12 means when a person approach in connection with spousal appointment, he shall disclose writing any circumstances. So why you want waiver of this? 5?
My lord, as it stands now, my lord, we are already processing the appointment of arbitrator.
No,
and we'll appoint within 10 days.
Why you want waiver of 12.5? Suppose a person is ineligible, that means he'll be eligible.
That's what they want to do, my lord. It is not permissible. Why should I sign that waiver?
Suppose you propose a person is eligible, if you sign a waiver, that means that...
But my lord, kindly say they are blowing hot and cold. We are appointing from the same list, my lord. They also are agreeing to appointment from the same list of arbitrators, my lord.
No, but there's dispute about then. If you are agreeing upon the same list, then why you can't just do it in a day or two?
So we are doing it, my lord.
Forget this
because the appointment has to be done because the appointment has to be done from the headquarters, my lord. And within 10 days, we'll do the appointment, my lord.
Forget this waiver agreement.
But they are also seeking appointment from the same list, my lord.
So I agree. Are you agreeable? So 1 second. As per the panel given by you, are you agreeable to this number 2?
My lord, engineer in chief will appoint as per the roster, my lord. There are 21 names. As and when the matters come, my lord, we maintain a roster. We will appoint as per the roster, my lord.
Then if you can't agree, arbitrator will appoint some retired judge then to do the arbitration.
No difficulty.
My lord,
if we are having difficulties...
My lord, we have no difficulty now, my lord.
Then?
Because initially we asked for signing this 12.5 waiver agreement. They have not signed it. We have processed the file and sent it to ministry, my lord, to the engineer in charge. Because there are 21 names, my lord, the appointment...
Whatever it is, why should he sign the waiver agreement? They may agree for waiver. agreement for appointment of serving officer. Is not retired.
Well, once I sign a
In
waiver,
fact,
they
now
can
it's
even
retired.
appoint a serving
No,
officer.
no, no, no.
I can agree to.
You know, please make this court understand why you want to appoint a serving officer.
But we are not appointing a serving officer now.
Then this waiver speaks such. It says that is a waiver that they have no objection to engineer in chief appointing a serving officer to be the arbitrator.
My lord, now maybe this is an old format, my lord. But now since 21 names list has already been issued, my lord, we'll appoint as per roster from the same list, my lord.
You'll do it in 1 week.
10 days time will
Let
do it,
them
my
do
lord.
it in 1 week from the panel that's been given. That panel is 7th February 2022. Yes, Dr. N. Mozika, Leonard DSGI.
Because I'll just clarify that the panel also has serving officers apart from the 21 names. So
Yeah, but the serving officers here also.
in the panel which my learned friend is referring, there are 21 names of retired officers, and there is a para below where it says serving officers are also there as part of the panel.
We are appointing a retired officers, my lord.
We will not say anything. Dr. N. Mozika, Leonard DSGI submits that on instructions, the arbitrator will be appointed by engineer-in-chief within a period of 10 days from today. Yes, list after 10 days for final orders, yes. I don't understand why you want to. What is this waiver? Anyway.
Daily list, item
Because
number
later
1.
on they raise objection, my lord, after arbitration is completed.
I will send it somewhere else.
Develop.
Yes.
May it please, Lordship. Lordship, kindly have this matter at the end of the board, Lordship. Senior counsel is still on next before other courts, Lordship.
It come after a day or two, Your Lordship.
Why?
I just want to go, Lordship. Some other matters. I wanted to go.
Go.
Got some.
Okay, today is Wednesday. Let's matter on Monday.
Much
obliged.
As the learned senior counsel for the petitioner is unavailable at the moment, let the matter appear on Monday. What's the date Monday? Today is?
26.
Today is 21st. 26, yes.
Item number 3.
And next date you will do it if Mr. Hamson is not there. Okay.
Lordship, I'd like to apologize. Let's avoid 26, Your Lordship. Maybe on 28.
Okay, 28th.
Item number 3.
In this matter, the pleadings are complete, my lord. I fix it for hearing, my lord.
Why did you pray that it be removed from the hearing list?
My lord.
Yes, who's appearing for the respondents?
I'm for the private respondent, my lord. The state is here.
Where's the state? Is the matter ready for hearing?
Yes, Your Lordship.
Yes, Your Lordship. Pleadings are completed,
You
Lordship.
all are on the same page. That's ready for hearing.
Yes, Your
The parties submit that, pray that the matter be listed for hearing. Yes. And this is a matter for hearing, so and so, yes.
Item number 4.
Look, I am requesting if this matter could be taken up next week because of the arbitration proceedings which are going on, and I have to
You
cross.
can't make that excuse, Mr. Pandey, before the High Court.
Well, I understand.
You can just say that there's some due to other circumstances.
Right. Seeking next week, my
But
lord,
you
or
kindly
any.
put an adjournment application. We'll pass orders.
Lordship, if I can request, my lord, there is
1 week.
There are two things, my lord. One is the petition that they have filed under Order 7, Rule 11.
That's not been taken up.
Which has been pending for hearing since last June, my lord.
Okay.
Their petition, and they are not pressing that petition themselves, my lord. Secondly, today
You're
morning.
pressing the petition.
No, that's not correct. We are pressing the petition, and for the hearing, we are saying that it may be taken up next week. And it was pending because the other connected matter in Gavin was going on, and at a later stage, the matter was detagged from Gavin. That is why there has been a
But Gavin's been disposed of, I think, the other matter, right?
Yes, it has been disposed of. That is
7-11 matter.
that is for the precise reason that hearing is required on that application, independently of that.
It's regarding presentation only.
It's regarding presentation. It's regarding
But
presentation.
one thing I would like to tell the council is that there's some applications which have been filed for, for the CCTV
Preservation of the
coverage.
CCTV footage.
That's not available anymore because it's preserved only for a certain period, maybe for...
That was my other point, because today morning they have filed a similar petition, in this case.
Application.
That's a redundant application, my lord. So as long as my friend undertakes to do the hearing on 7/11 next week, I have no problems. It can be adjourned.
That can...
No, I mean, we'll pass orders then on the application adjournment. You please file it. Yes,
We'll file it. We'll file it within the course of the day.
CCTV, there's no point because
There's no point.
you know how it is. You don't.
I understand.
You should have done it at that point of time. Yes.
5.
Plus 5 is the matter in Gavin, which both the sides have filed
No,
their
the
proposed
issue has to be settled, madam.
Then we'll
Since
settle
I have already submitted my issues, it was on...
Have you filed your suggested issues?
Yes, we have filed it, and
It can be settled.
more or less...
They can be framed. Because only court has to decide, my lord, how the issue has to be...
Then, you kindly...
Because I have submitted, my lord, 3 issues, my lord, as per my 22nd November 23, my lord, in this application. There are 3 suggested issues from my side, my lord.
Where is it? 1 second. Yes. And where's the draft?
My draft issues, my lord, is submitted on 22nd November 23.
This is Palas with whom?
Pala is from the side of the respondent. Well, we have filed it on 6th of February 2024. Thank you.
Yes, I mean, both of you have filed similar
issues. These are similar issues, Manoj.
So only one thing is that you'll have to furnish your list of witnesses.
List of witnesses.
And then the schedule which you would like to, which is convenient to produce that, because then summons have to be issued, you have to request the registry with the correct address as per it.
Yes, my lord.
It says per CPC, you have to give the correct address, what is the nature of the witness.
So we will file it within 1 week, the list of witnesses, and after that, my lord, it may be taken up after 3 weeks so that matter can be started.
Okay, the court will file, will draft issues later. Yes, the such issues have been framed by the petitioner respondent. Specific issues which will be, but that's the specific issues or as follows. Just leave it like that.
Yes.
And then next part is that parties further submit that. And you give a separate page the issues, something like that, then the separate page that I then parties submit that the list of witnesses will be filed within
1 week, my lord.
Within 1 week.
Yes.
Within 2 weeks.
No, 1 week. Only submission of the list of witnesses. Nothing will be
Within
done.
2 weeks. Yes. So then you think of a schedule also. How many witnesses you going to have?
Schedule, my lord.
So that, and you can you will file by affidavit also. So those things all.
Yes, in the middle week of March, my lord.
Okay,
Once we have a list of witnesses, and then we'll be in a.
You give your date.
Yes, madam. Middle week of March, any day, madam.
Okay. 5, 6, 7. Those are for exemption witness. Any different case of anyway. Okay, we'll give a rate mid-March.
Yes, madam. 5th March, madam.
Yes.
Item number 6.
Obliged, Lord.
By the time this witnesses.
Lordship, service completed, but respondent number 2 and 3 are yet to appear, Lordship. Respondent number 1 appeared and last time, and they have sought time for filing affidavit, but they have not filed any affidavit, Your Lordship.
2 and 3?
2 and 3.
For respondent 1.
Where 2 and 3? 2 and 3 is whom?
2 is the Chief Secretary.
This is regarding a salary only?
Yes, Your Lordship.
But you saw a statement that you'll be getting money now to clear the salaries of
because
the...
as per instruction, Your Lordship, they have got salary only till April 2023.
No, there's been some development, which is in common knowledge.
If the respondent number 2 and 3 will have appeared, it will have been clear, Your Lordship.
They've been served.
Yes, Your Lordship. Service is
Sir, why
completed.
they have not appeared? You for the council, correct?
Lordship.
You tell them, I'll not record, but then if you don't... Oh, no,
Lordship,
just give
2
you
and 3
Walang
are
and
state,
top.
Lordship. 2 and 3
Where state?
State.
Who's appearing for the Chief Secretary?
Service is completed, Your Lordship, but they're not appearing since last date.
We'll take instruction on this. We'll speak to the department if they have to say.
Those, though service is complete on the other respondents, namely the Chief Secretary, the Government Meghalaya, also the Commission Secretary, the Council Affairs Department, no appearance made on his behalf. This court takes serious note of the same. If no appearance made next date, they will, the set respondent have to appear personally. Yes.
After 1 week, Lordship.
Lordship, so far as the district council, we need some
You
more time,
file your
Lordship. You
affidavit?
file affidavit, Lordship.
1 week
Because
time,
we're taking...
Lordship.
Because
You
there
filed
are-
it?
I'll be filing the Lordship.
When?
I'll
The
require
course of
2
the
weeks
day?
time. 2 weeks time.
1
Because
week,
there are
Lordship.
correspondence between the district council and the
Okay,
state
yes,
government.
this matter up to 2 weeks, yes.
2 weeks, Lordship. Very good, Lordship.
7.
It takes court serious note, and the person appears to call for next date. And another thing is what Mr. M.L. Nongpur prays for the 2 weeks time to file affidavit. Yes.
Lordship, filed our affidavit here. Respondent 2 brothers.
Yes. Yes. What do you want today?
On the last order, Lordship, the license was given to the respondent number 8 to appear.
Then they're not here today.
Not here today, I guess. Lordship.
They've been served.
Yes, Lordship.
They've been served.
Yes, Lordship.
Where is that?
On 3/7, Lordship.
You filed affidavit.
Yes.
After service. Let's see.
Perhaps, my lord, it was indicated in the office note, my lord.
1 second.
3rd July 2023.
3rd July. 3rd July?
2023.
23.
2023.
Service.
3/7/2023. There is an order, Lordship.
Yes.
3/7/2023.
Yes. Who's respondent number 8?
He's
the brother of the petitioner, Lordship.
He's the brother of the petitioner.
Petitioner, Lordship, yes.
Then you can't serve your own brother.
I can.
He knows of the case.
Yes, Lordship. He has.
I think they're staying in the same.
They're staying in the same house.
Not same house, Lordship.
Same area.
Same compound.
Same area, Lordship.
And he doesn't know that you file a case against him.
He knows, Lordship.
He's not appearing on purpose.
Yes, Lordship. Because
Then we'll go
thrice,
party against
Lordship, thrice he filed a case and withdrawn, and he has that in third case also he has not revealed all those facts. Consequently, my lord has imposed cost on 10,000. He has suppressed lots of material facts.
So he paid 10,000.
10,000. I am not aware whether he has paid or not, Lordship.
What's the matter about actually?
This is Lordship. There are 2 brothers. Both are fighting for the property left behind by the father, my lord. One is on the strength of the will, which has not been probated, and the other is in the strength of a order passed by the district council, but no mutation has been done till date. So he is here for the enforcement of the mutation, my lord.
So, what have you said in affidavit?
My lord, in affidavit we have said, my lord, that considering the various round of litigation in the dispute, we have not acted upon it just to avoid, my lord, the further complications.
Here, Lordship, we are not asking any rights, Lordship. Father died, Lordship. Then the property automatically devolved upon the two sons, Lordship.
Paragraph 5.
Two sons. Only issuance of joint patta, Lordship. Issuance of joint patta. It is not that I am seeking for patta in my favor. Issuance of joint patta. The property devolves upon both the brothers. It is not a case where I have come to enforce or to create a new rights, Lordship. My rights has already been there.
Huge piece of land, 52 bighas.
Yes, Lordship. And time and again, District Council has issued order asking the mandal of the concerned area to issue the patta, Lordship. They are not acting on it.
If my lord may come to my lord page...
1 second, Mr.
Lordship.
Yes, what are you saying?
My lord, Lordship may kindly come to page 27, my lord, annexure 4.
Page 27.
Page 27, annexure 4. This was the order passed by the District Council, my lord, for the joint.
Yes.
Here, my lord, if Lordship will see the fourth paragraph, my lord, but the respondent claims
Yes.
that a will was executed by his father in his favor and thereby the appellant was deprived from share. However, despite many chances given to the respondent, he could not produce the will. As such, my lord, a direction was given to jointly mutate the land. Thereafter, my lord, if Lordship kindly comes to page 30, Lordship. Annexure 7.
Yes.
This, my lord, is the order passed by this honorable court on 18th of October. Lordship will kindly see paragraph 2, 3 and 4. He came up with the will, my lord, before this honorable court.
Para?
Para 4, my lord, at page 30.
Yes.
In view of the above, learned counsel of the petitioner prayed that she may be allowed to withdraw this petition with liberty to take appropriate proceedings for establishment of authenticity of the will dated so and so executed by the father of the petitioner in his favor.
But even then, let them do the mutation. Mutation is not a document of title. It is a record of rights. I mean, if they have any question of title, they can do civil court. The entry of his name or that respondent by its name in the record of rights and Bandi does not vest them with any title.
What my friend is referring, that is the will. That is the case filed by the respondent, not myself.
Yes, yes. So we are only saying that because we don't really know whether they have gone for probation proceedings or not.
It doesn't matter.
I think my learned
if he's not interested in contesting on receipt or notice, that means that he has reasons. Are you appearing for number 8?
We have no interest in.
I'm appearing on behalf of Advocate Amit Joshi, Lordship. He just informed me that he has had some medical emergency in family. I've received instructions to ask for 3 weeks' time, Lordship, to file his affidavit, Lordship.
Then why didn't you say from before, waiting for the court to pass or ex parte hearing?
Lordship, I was.
Yes, today Mr. S. Pandey has entered appearance on behalf of respondent number 8 and prays allowed 3 weeks' time to file affidavit. As this matter has been lingering for some time, both at the revenue courts and before this court, 2 weeks' time is granted. You filed for affidavit. Thereafter.
We have already
filed.
You filed, you said you helped. You're not doing it because there's a dispute.
No, that is the only embargo.
Item number 8.
Affidavit, my lord.
My lord, the list of the ad hoc employees have been already forwarded. We are waiting for the consideration, my lord.
For
consideration, my lord. And in the list,
ad
the
hoc
petition.
employees meaning?
My lord, for regularization, my lord, I'm not very much brief with this matter.
Where's that
but
Eno can read?
She is, my lord, she has to go to the court number 1, my lord. So, my lord, what we have, the instruction
No
which we
court
have is...
proceeding at the moment, yes, huh?
So, my lord, our instruction says that the petitioner's name is also part of the list. So, we are waiting for the consideration, my lord, from the competent authority.
Yes, MSR only submits that the petitioner who's an ad hoc employee, along with other names, have been sent for consideration before the respondent. He is also allowed 2 weeks further time to obtain necessary instructions.
Item number 9.
My lord, item number 9 and 10 an analogous matter. Here, my lord, we are yet to file our affidavit. I have already prayed a number of times, my lord, on behalf of the state.
Why?
5 MPSC. Oh, private respondent.
Does MPSC matter?
No, my lord.
What's the matter about?
Your Lordship, this matter is about the redrawing of the select list after the petitioner was already in service, Your Lordship.
Of the withdrawing of select
Redrawing
list?
the select list after the petitioner was already in service, Your Lordship. And the state is just to find the affidavit, Your Lordship.
Okay. Yes, sir. When can you file it?
My lord, our instruction is very dicey, my lord. We are not getting a clear instruction from a department concerned. So we are
might
consulting.
implicate yourself, you mean, if you file affidavit.
That's why, my lord,
Yes,
we
so
need
further 2 weeks'
clarification
time
on
as
our
granted
instruction.
To the response for the affidavits. It is noted that numerous opportunities have been granted. It is expected next year the affidavit should be on board, yes.
My lord. 9 and 10, my lord.
Item 11.
Your Lordship, I have just received, Your Lordship, the affidavit filed by respondent 1 to 4, Your Lordship.
Yes.
We filed it yesterday, my lord.
Yes. Yes, and what
So
about
far with
number 5?
respondent number 5, Your Lordship, we are still waiting for service report.
You only filed yesterday.
Yes, Your Lordship.
The affidavit respondents is submitted that the affidavit behalf of respondent 1 to 4 since been filed. Mr. Dihunta service status on of service respondent number 5 is awaited. This after 2 weeks for rejoinder and for service report on respondent number 5.
All right.
12.
Lord, I pray for 2 weeks' time to file an affidavit.
13 also, my lord.
Similar matter. Your Lordship.
12.
What's the matter about?
Regularization of service, Your Lordship.
PWD? PWD or which department?
It is
PWD, Your Lordship. The petitioners, this second round of litigation, Your Lordship.
How many petitions are there? Only 1?
2, Your Lordship.
Just a moment. Why? Who's appearing for whom?
I'm appearing for item 11. Item 12.
I'm for 12, my lord. Item number
12.
12. Or 13.
This is 12 years, 12. 12 moment, 13, 12. 2 weeks, further 2 weeks granted to the response file affidavit. As prayed for the 2 weeks granted, yes.
14.
Yes.
Item 14 and item 15 of the
Why you not
hearing
filed?
list. My lord, I was doing my research trying to find out a way to resolve this issue, but I could not file anything. The only legal issues are involved, my lord may kindly have it for hearing.
You ready?
My lord, affidavit is not on record, my lord. So
Affidavit is not on record, but in the connected matter.
What's the
my lord,
matter
yeah.
about?
this is regarding, my lord, non-payment of allowances, my lord, to the petitioners, my lord.
Who are the petitioners?
They are the employees of the Muda.
Muda.
Yes, my lord. Now, my lord, in terms of Jagjit Singh, my lord, we are paying them the minimum pay scale, my lord. Now they are seeking for the allowances, my lord, service benefits.
How do you
Which
appoint
we are getting earlier, my lord.
How
As
are
per
you
the
appointed?
Temporary basis, my lord.
temporary
They're
basis.
temporary employees, my lord. So either they can show the law, my lord, then I will help them out, my lord. But I could not find anything, my lord.
My lord, as per the Jagjit Singh, my lord, temporary employees are also entitled for the allowances, my lord.
So we have complied with that, my lord.
LDA, record keepers on the process server. State no affidavit. What would this matter then? Was it for hearing?
For hearing, my lord. It's only legal points.
Parties submit that the matter be listed for hearing, as the points in issue are mostly on law. Stop on law. However, it is provided that the respondents may file affidavits in the meanwhile, yes, after 3 weeks. Yes.
Item 15 is connected, my lord.
Supplementary list, hearing. Item 5.
Nectar.
Please, Your Lordship, I'm praying this matter be taken up after some time, Your Lordship.
No objection, Your Lordship.
After some time.
Daily list, item 16. 16.
Lordship, here I was supposed to file one affidavit stating that whether I have entered my appearance when the case was filed before the court at Tura, before the transfer as well as creation, separation of the judiciary, Lordship. But Lordship, what the instruction, Lordship, I could not file the affidavit, Lordship, because it was a case, in one order sheet it reflects that she entered her appearance, Lordship. But thereafter, the matter was proceeded for step, service of notice and appearance and step, and no further order was passed, Lordship. And in that order, Lordship, there was no, when the matter was proceeded before the trial court at Tura, nowhere mentioned that the parties are allowed to file the written statement. Only the matter was proceeded for steps and appearance of the parties. Then 2016, Lordship, the matter was transferred to Ampati, Lordship. Then 2017, then separation took place. The matter was transferred to the judicial section, Lordship. Then, Lordship, I have that my friend has enclosed the entire order sheet, Lordship. That is at page 36 in the order sheet, Lordship. These are the orders they have passed after the separation of the judiciary, Lordship.
Where we're referring to?
Page 36 of the order sheet supplied by the respondent, Lordship. This is photocopy of
36?
36 page.
In the petition?
Yes, Lordship. Not in the petition, Lordship. The separate order sheet. This is on place on record, Lordship.
Yes, yes.
The first order was first 11/5/2017, Lordship. CR put up today.
1 second, I've not got the order sheet. It's not with us.
Lordship.
You have an extra circular.
How come it's not here on record? Did you supply it? No.
I had supplied one.
You are sure about that? The documents don't get lost there. If they're supplied, they'll be here. They'll be here.
This is another order sheet.
Don't be
I have another copy, Lord.
Your number records. Records have been called.
Yes, yes.
Check it out for records. You kindly get your website, yes. Yes.
Lordship, after the separation, the first order was first 11/5/2017.
Give me that. Yes. After?
The matter was transferred.
Page 30?
Page 36, Lordship.
It was handwritten, yes.
Handwritten.
36?
36, Lordship.
Yes, 17. Receive or issue notice, reissue notice to defendant.
Lordship, this is the page number, Lordship.
The one below or one
Yes,
on top?
the up top, Lordship.
36, correct?
Yes, Lordship.
Yes.
The order sheet 11/5/2017, Lordship. CR put up today, seen the office order of the learned Additional Deputy Commissioner, Judicial, Southwest Garo Hills, Ampati, endorsing the case to my file for disposal. By notification dated so-and-so, I have been appointed and invested with powers as Judicial Magistrate First Class and Assistant to Deputy Commissioner, Southwest Garo Hills, Ampati. Issue notice to the parties. Fixed 36/2017 for appearance and stay. Then 36, Lordship, CR put up today, reissue notice to the defendant as not served. Then refix on 25/7/2017, Lordship. The typekeeping is next page, Lordship. Then 25/7/2017, CR put up today, learned STCS Marak present in counsel for the plaintiff, not legible, on notice to defendants. Reissue notice to the defendants. Fix 17/8/20. It ought to have been for 2017 for appearance and steps.
Actually, 17 is 17.
Yes, 17, Lordship.
But
Yes,
you typed it as 12.
Yes, Lordship, 17. Now, Lordship, 17, there is no order, Lordship. The matter was listed on 22/8/2017. CR put up on call. Case was taken up dates certain fixed as the magistrate was on official duty at Shillong. Reissue notice to parties fixed 27/9/2017.
Yes.
CR put up today non-present receive a reissue notice to the parties fixed 3/10/2017 for appearance and steps.
Who wrote this? I mean, it's totally misleading now. Yes.
Then matter is
receive notice and reissue.
Yes, Lordship.
Yes.
It should be reissued. 30/10/2017, CR put up, son of the plaintiff, Dilip Rajbor present and stated that time may be given to the counsel as the counsel is unable to appear due to unavoidable circumstances. Refix 7.
This unavoidable becomes unavailable circumstances.
I apologize.
7/11. Now 7/11/2017, Lordship. CR put up today, learned TSC Marak present in the court for the plaintiff and filed the copies of the plain and the relevant documents. Learned counsel S. Chakraborty present and filed Vakalatnama and is representing the defendant. It should be 4, Lordship. To notify that GP
What?
to defendant number.
What?
Learned S. Chakraborty present and filed the Vakalatnama and is representing the defendant number 4. BA2. BA2 reissue which is defendant BA2 the GP reissue,
BA to notify the GP.
notify the GP.
Reissue notices to defendants 1, 2, 3.
To the 1, 2, 3.
Copies furnished defendant number 4.
Defendant number 4, Lordship. That is on, I have received the copies on 7/11/2017,
Oh,
Lordship.
you are number 4.
I am 4, Lordship.
In the suit.
In the suits, Lordship.
Yes.
Now, fixed 28/11/2017 for appearance of the defendants 1, 2, 3 and steps, not for filing of written statement, Lordship. Then, Lordship, matter was listed on 28/11/2017, Lordship. CR put up today and Sangma, not legible. Executive, very difficult, Lordship, is present. Defendant number 3 and has received the copies of this, not legible. Learned Counsel at Chakrabarti is present for defendant number 4. Learned AGP, Srimoti T.D. Sangma present. Taken Dilip Rajbor present, son of the plaintiff, fixed 6/2/2018 for filing of written statement.
Okay,
Earlier,
so
the
first
matter was fixed for only for appearance of the parties, Lordship.
Okay.
I have received the copies on the day when I entered my appearance after the separation of the judiciary, Lordship. Now, the matter was posted for 6/2/2018, Lordship, for filing of written statement. Now, 6/2/2018, Lordship, CR put up, Learned Counsel A present, Hossain present and
One
filed.
second. By order date 28/11/17, 6/2/18 fixed for the US. Yes. Then
Now, the 6/2/2018, Lordship.
CR put up.
CR put up, Learned A. Hossain, Learned Counsel A. Hossain present and filed Wakalatnama and is presenting the plaintiff. Because the plaintiff entered her appearance through counsel on 6/2/2018. The Learned D.A. Sangma Assistant GP present for the defendant number 1, 2 and 3. Learned Counsel at Chakrabarti present represent defendant number. The defendants come prayed for time to file the written statement fixed 22/2/2018 for filing written statement.
Yes.
Now 22/2/2018, because the presiding officer was on leave, Lordship, the matter was taken on 28/2/2017, Lordship. CR put off on call as I was on leave on the last day fixed. Learned Counsel for the plaintiffs and defendants present, Advocate A. Hossain, AGP Srimoti D. A. Sangma and Learned Advocate S. Chakrabarti. Defendant number 4 has filed WS today. The Learned AGP has prayed for time due to not legible legislative assembly election. The plaintiff has objected to filing the WS. Refix 5/3/2018 for filing of WS by the defendant number 1, 2 and 3.
Yes.
Lordship, on 28/2/2017, on the time granted by the court, I have filed my written statement. And so far as the written statement with regard to the other respondent, other defendant concerned, the respondent has raised objection. The respondent has raised objection.
Yes.
Then the other respondent has filed the WS. The matter was fixed for hearing. That is at page, Lordship. That in order is at page 27/3, Lordship.
Of the application.
Yes, Lordship.
Okay. 27/3.
The plaintiff did not file any.
What about his order 33rd of March?
This is, Lordship, this is for filing of CR put up today, Learned AS present, represent the plaintiff, AGP.
They filed
I have,
1, 2, 3.
They have also filed, Lordship.
Yes, so that date's important also.
Yes, Lordship.
This is 3rd of March.
Yes, 3rd of March. This is 5th of March, Lordship.
Oh, 5th of
3rd or
March.
5th.
Okay. 5th. Okay.
5th of March, Lordship. The plaintiff has objected to filing to the WS of the respondent number, other respondent 1, 2, 3 Lordship, not mine, Lordship. Now on 27 3 Lordship, that is the impugned letter order, Lordship.
Is impugned here?
Yes, Lordship.
Yes.
May I read, Lordship?
Yes.
Here put up today, Learned A. Hossain for the plaintiff is present. Learned counsel for the defendant number 1, 2, 3, AGP, Srimati D. A. Sangma, and Sri S. Chakravarti for the defendant number 4 is also present. The counsel for the plaintiff has submitted that the plaint was filed after 90 days due to the circumstances beyond his control, as the defendant number 4 is a resident of Uttar Pradesh. And also the court was not...
I don't understand. Why counsel plaintiff's claims was filed beyond 90 days?
Lordship.
It's a typographical mistake. It should be defendant
Defendants.
in WS.
My lord...
It's a mistake in the order sheet.
Yes.
It should be defendant and WS instead of plaintiff and plaint.
Okay.
Now the council also heavily relied on the decision of Salem Bar Association versus so-and-so, where Rule 1, 9 and 10 of Order 8 were harmoniously constituted as an extract of the judgment which are relied on is reproduced below, Lordship. This is the judgment, Lordship. Now, next para, Lordship, Learned AGP has declined to make any submission. The Learned Counsel for the plaintiff, though has in principle agreed that in exceptional circumstances the court can allow written statement to be filed after 90 days, has raised an objection in this instant case and has placed the reliance on a judgment of the Honorable Supreme Court in Kailas Nangkhu, where it was held that para 43, a prayer seeking time beyond 90 days for filing the written statement ought to be made in writing. In its judicial discretion exercised on well-settled parameters, the court may indeed put the defendant on terms including the imposition of compensatory cost, and also may also insist on affidavit, medical certificates or other documentary evidence depending on the facts and circumstances of a given case being annexed with the application seeking extension of time, so as to convince the court that the prayer was founded on grounds which do exist. Para 44, the extension of time shall be only by way of exception and for reasons to be recorded in writing, howsoever brief they may be by the court. In no case the defendant shall be permitted to seek extension of time when the court is satisfied that it is a case of laxity or gross negligence on the part of the defendant or his. In the instant case, all the defendants have filed their written statement after 90 days and no prayer in writing has been made praying for extension of time. The Learned Counsel for the defendant 1, 2, 3 has declined to make any submission, though it is agreed that the exceptional circumstance written statement can be filed even after 90 days. Certain guidelines and steps need to be taken as averred by the Learned Counsel for the plaintiff. In the instant case, there is no prayer being made in writing for condemnation of delay and extension of time to file written statement, nor any affidavit, nor annexures being submitted. I am inclined to agree with the submission of Learned Counsel for the plaintiff that there was no circumstance warranting an extension of time to file the written statement and there was laxity on the part of the defendant. For the foregoing reasons, I am of the opinion that there were no exceptional circumstances to allow the written statement to be filed after 90 days in the instant case. The filing of written statement is thereby closed. My lord, my lord, it is not a case that there was a negligence on my part. The court has already allowed the time for filing the written statement. It is nobody has prayed for filing the statement. It is the respondent number 1 and 2. They ask for time.
Yes.
Ask for time, and on that day the plaintiff has objected for not to grant further time to the other defendants. So far as my case is concerned, Lordship, the plaintiff at the time of enlarging time to the defendants, he has not raised any objection. That is the first order, Lordship. When the court has granted time, he should have raised any objection, or he should have...
See order 28 to 17 then. But with regard to you, it doesn't say anything. Only that objection is to difference 1, 2, and 3.
Yes, true, Lordship. That is my case, Lordship. Now I have filed, Lordship.
Yes.
The petitioner, the respondent could have objected on the day when I was allowed to file the written statement, Lordship. He did not make any prayer for closing of the written statement. Now, the order passed with regard to the other respondents, not with regard to the respondent number 4, Lordship, defendant number 4. So where is the laxity and the negligence on my part, Lordship?
Yes.
Order 8, Rule 1, just to why that legislature has framed the rules so that the defendants should not play the dilatory tactics to linger the proceeding, Lordship. So on my part, there was no laxity, negligence. I have filed the written statement on the time granted by the court, Lordship.
You filed it on 28/2/17.
Yes, Lordship.
Okay. 17.
Thereafter, Lordship.
Yeah, nothing is there. I mean, no, but it's recorded there. The alleged EGP's period of time, election, the plaintiff objected to filing of WS, but it's not clear. Anyway, yes, continue.
Then, Lordship, then matter was proceeded. Then the counsel, who was representing the defendant, did not inform the petitioners, who is a resident from
now
UP.
The lawyer who was representing defendant number 4.
Yes, Lordship.
Did not inform you
About the closing of the written statement.
Okay.
Then subsequently, I have engaged one lawyer. Then I put up application for
That was not informed you about closing your statement.
Yes, Lordship.
That means that even after filing on 28/2/17, it was rejected by the
Lordship.
order dated
Yes.
27/3/18.
Yes, Lordship.
Okay, yes.
Then I,
on the ground that no application was put for the delay.
without any documents, Lordship. Then thereafter, Lordship, I put up application for setting aside the order dated 27/3/2018, Lordship.
Yes.
That has also been rejected, Lordship.
Where is that? Where?
That is in my petition, Lordship.
And in this compilation?
In compilation, Lordship. Compilation 5. No. 6/9. In the compilation, Lordship, it will be page 88, Lordship.
88?
88. In the compilation order sheet. Long order, Lordship. Here also, Lordship, the learned trial court has referred all the judgment, Lordship, the Salem Bar Association, Kailas Nanghu. After referring all the judgment, Lordship, the application for revoking, setting aside the earlier order was again rejected, Lordship.
That order dated?
6/9/2019. Yes, Lordship.
Yes. Ground of rejection, where is that?
Yes, below, Lordship, here. We start from 90, Lordship. I find that the above said judgment has no relevance to the present case at hand. This judgment was rendered in challenge to order rejecting the petitioners to allow them to file additional documents and not for the condemnation of delay in filing the WS. The learned counsel also referred to another Guwahati High Court judgment in so-and-so, but upon close scrutiny it was found to have suffered from some infirmity as it relates to an appeal for condemnation of delay 65 days in preferring the appeal. Learned counsel submits that the decision of Guwahati High Court in Dulumoni Saikia versus Narendra Nath Sharma, I have carefully examined the said judgment wherein the facts and circumstances of the case was different. The prayer for grant of time to file the written statement was made. In the above case, unlike this case, where no such prayer was made for condemnation of delay, this court, upon careful examination of the case records, find that the counsel for the petitioner was shown to have regularly attending the court. The petitioners have not given any satisfactory explanation why no step prior to this present petition was made. The petitioner also did not explain why it has preferred this petition after a delay of more than 1 and 6 months from the date of order dated 27/3/2018. The petitioner also did not show any exceptional circumstances in this petition for condemnation of delay. I find that the entire matter shows that the petitioner was guilty of laches and negligence in filing the petition for setting aside the infine order dated infine order and whereby to allow filing written statement. In Salem Bar Association, Tamil Nadu versus Union of India, so it was held that the time can be extended only exceptional hard cases. While extending time, it has to be borne in mind that the legislature has fixed the upper limit of 90 days. The discretion of the court to extend the time not to so frequently and routinely exercise so as to nullify the period fixed by order dated Order 8 Rule 1. Therefore, on considering the above rulings, the Salem Bar Association on foregoing observation, this court is inclined to reject the petition. Here, Lordship, the Salem Bar Association also says that frequently the defendant should not ask frequently time for filing the written statement. Here, where is the frequent, Lordship? Not even twice I have asked for filing the written statement. What is the negligence and laxity on the part of the defendant in the proceeding, Lordship? And so far as the settled principle of law, Lordship, my Lord is aware of the judgment and the principles that mandatory and the directory. So, with regard to that issue, I am just referring. Here also that the Kailas Nanku was referred, Lordship. After referring, the Supreme Court has allowed the filing of the written statement. But my case, my Lord, written statement is already there. It is still on record, Lordship.
Yes.
Very small one. Another judgment, Lordship. This is reported in live law, Lordship, not yet reported in SCC, Lordship.
Yes.
Here also the defendant appellant is an appeal against an order passed by the High Court of Judicature at Allahabad on 31/2018, whereby the written statement filed by the defendant was not permitted.
But the thing is that, see, Mr. Sheikh, your case is that there was no objection to them filing the statement on 28/2/17.
Yes, Lordship.
The basic objection was to the written statement of the other defendants.
Other defendants.
So the whole proceedings went after that also was, but the only hiccup in your case is that after How long he didn't appear anymore in the case? How many dates?
Lordship, as per when I came for setting aside the earlier order, Lordship, as per the record, it shows that I came 1 year, 18 months. That is the second order, Lordship, 18 months. The second.
You didn't attend to the case?
Yes, Lordship. After closing my written statements, as per the order sheet, that there was a delay of 1 year and 18 months. My Lord, only one thing is that where is the negligence? Did I make any attempt to delay the proceeding, Lordship?
With other judgment would you show? This one?
Yes, Lordship. Here the learned trial court has taken a contrary view, although they have referred the Kailas Nangku and as well as the Salem Advocate Bar Association. But she has taken a different view.
No, the only thing Salem Bar Association say that that shall not be read as mandatory. Shall can be read as directory, provided you. Yes.
Even the Kailas Nangku also says that this is a directory, not the mandatory. Yes, sir.
That's it.
Yes, Lordship. And one relating to the same issue, Lordship, here that our Honorable High Court has decided the matter, Lordship.
Justice Mittal's judgment.
Mittal's judgment, Lordship.
Yes.
So, Lordship, there are two parts to it. Lordships will recall this matter was heard on the 4th of October 23.
Before where?
Before this court, my lords.
It was heard?
4th of October 23.
One note also in my file.
It was heard. My lords will see the order sheet. The order reads, Learned Counsel for the petitioner prays for 2 weeks' time to obtain necessary instructions in this matter from his client. Now, the issue was, we had referred to the order sheet which is before Lordships. Kindly see page 3 of that order sheet. It's one thing to say that they received notice after the matter was transferred to the Ampati court. And they received notice in 2017. And it is their case that the time period for filing of written statement should be calculated from that second round where they received notice. Now, the order sheet indicates that notice was received in 2009 itself.
2009?
2009. So kindly have that order sheet, page 3. The trial court order sheet.
Yes.
Can you see the first order, 31/7/2009. Plaintiff present and represented, defendant number 2 and 4 represented by their lawyer. So when Lordships confronted them with this particular order, they had prayed for time to obtain instructions from their client.
Oh yes, now I remember, yes.
My lord.
2009, that's what. Did you appear? Did your client say they appeared in 2009?
That is why, Lordship, she could not recollect. It is a 1.5 decades ago, Lordship. She does not know how to write and read, Lordship. She used to put her thumb impression, Lordship. It was in 2009, Lordship. And after, since my friend is referring, Lordship, let him to proceed.
So, after being confronted with this, apparently my learned friend sought instructions from his client. On the next date, that is 30th of 10/2023, this is what is recorded by Lordships. Mr. S.A. Sheikh, learned counsel for the petitioner, submits on instructions that the respondent was never served and as such is prevented her from appearing on the concerned dates. He prays for and is allowed to put the same on affidavit because this was merely an oral submission. So Lordships permitted him to file an affidavit. Till date, no affidavit has been filed.
Why you not file affidavit?
My lord.
You also lost sight of the orders
no,
passed by the
Lordship,
court.
she could not recollect, Lordship.
No. You say that now your submission is that as per what Mr. Sen has said, that they never were served.
But this is the record shows that she had entered appearance and after what is the order afterwards, Lordship? Whether this.
So you're concerned with the happenings after that?
Yes, Lordship.
It doesn't matter that the court has, because of what's happening in the middle, the separation and so on and so forth, the court has already overlooked all these requirements of law and has allowed you to file a written statement, which you did on 5th of on 28th of February 17. So if the suit is instituted in 2009.
2009.
Whether there is any order allowing the parties to file the written statement, that is only for interest. After that, kindly see the subsequent orders, Lordship. What had happened afterwards, Lordship?
My lord, in that respect, I would humbly submit.
Had there been an order to file written statement, then they could have objected for filing a written statement. Then if the court could have, ought to have closed my written, then I would have.
What goes against them is that On the relevant date, they didn't object to the final statement by you.
No, I'll just come to that, my lords. It's actually recorded. It's recorded. I'll just come to that. To just counter that, what my friend says is that there should be a judicial order directing a party to file written statement. Only then the time begins to run. That is, in my humble submission, incorrect. A P5 form clearly indicates that the party has to file, be represented by a counsel and file the written statement. The time periods gets activated from the date they receive the summons, irrespective of whether the court passes an order or not. Now, the other part that my friend has referred to, that the order sheet does not indicate that I have raised an objection. Kindly see that particular date. This is the order dated 28/2/2017.
'22. The date they filed the statement?
Lordship.
28/2/17.
Just coming to that. 28 to 27, it's at page 46.
Excuse me.
You lordships have it?
Yes.
See, CR put up on call, as I was on leave on the last date fixed, learned counsels for the plaintiffs and defendants present, Advocate A. Hossain, AGP Srimati D. S. Sangma and Advocate S. Chakravarti. Defendant number 4 has filed WS today. Learned AGP has prayed for time, due to ensuing legislative assembly elections. The plaintiff has objected to filing of the written statement. This relates to the written statement being filed by the defendant number 4. An objection was duly raised on that particular date. Now kindly turn to page 48. This is an order dated 5/3/2018.
Yes.
This reads, CR put up, Learned Counsel A. Hussain present representing the plaintiff, Learned AGP present, D. A. Sangma, Srimati D. A. Sangma present for the defendants 1, 2 and 3 and filed WS. The plaintiff has objected to the WS. This is a second objection to the state's WS.
Okay.
But as far as the defendant number 4 is concerned, that objection was raised on that very day.
On 28 itself.
28 itself. Now, there's another thing my learned friend has just glossed over. The laxity on their part. Can you have their revision application, my lord?
Page?
Of the revision application, page 23. This is the first order on the basis of our objection. The court heard the parties and passed an order dated 27/3/2018.
Yes.
And came to the finding that there was laxity on the part of the defendants, not the counsels, but the defendants themselves.
Where's the finding?
My lords, at page 24.
24?
Page 24.
You're referring
of
to
the
order-
revision application.
Okay.
Annexure 3.
Page 24.
This is the order dated 27/3/2018.
No, revision application 24, something else. You're referring to order dated?
It's order dated 27/3/2018.
2018. What page is it in the? What page is it in your revision application?
This in the compilation also in.
In your revision application. 23, no?
Yes, yes, 23.
23. 23.
Annexure 3. First implement order.
Page?
23.
Yes, that's it. The same one you read just now.
Lordship, can you have page 24, the next page?
Yes.
The finding of the court. The second paragraph, my lord. In the instant case, there being no prayer made in writing for condemnation of delay, extension of time to file written statement, nor any affidavit nor an extra being submitted, I'm inclined to agree with the submission of the counsel for the plaintiff that there was no circumstance warranting an extension to file a written statement, and there was laxity on the part of the defendants. So this is the finding of the court. Pursuant to this, they filed an application, which is Miss Case 69 of 2019, which is at page 25. I'll just read out the contents of this. This is relevant, my lord. So this is a petition under section 151 CPC praying for setting aside of the order dated 27/3/2018, which we read earlier, read with section 5 of the Limitation Act for condonation of delay. It's one thing that section 5 would not be maintainable in these circumstances, but the content is relevant. May I just read, my lord? That the petitioner defendant of the above noted title suit, on receiving summons, engaged learned advocate Sri Sameer Chakravarti for taking all steps and on bona fide good faith, handed over all relevant documents in connection with the suit, who without informing petitioner defendant, withdrawn his wakalatnama from the suit. That on last 19/7/2019, the engaged counsel informed one of the relatives of the petitioner defendant that Sri Sameer Chakravarti has withdrawn his wakalatnama from the suit, and today, the date 16/8/2019, has been fixed by this honourable court for evidence, and hence the petitioner defendant engaged learned advocate Sri Ruparaj Ghatak, who on perusal of record informed the petitioner defendant that there is no WS in the record, an ex parte order, kindly take note of this, and an ex parte order was passed by the presiding officer Sri TTM Sangma on 27/3/2018 on the ground that the previous engaged counsel made no prayer in writing for condonation of delay for more than 90 days extension of time to file written statement, and thereafter the previous engaged counsel never taken any steps towards filing of WS, and hence this petition. So this is incorrect. This was not an ex parte order. Now can you just turn to the order that they've enclosed, a certified copy of the order. So this application is filed on the 16th of August 2019, enclosing the certified copy of the impugned order. If Lordships have page 28, kindly see the date of application of the order. 13/8/2018, and date of receipt 16/8/2018. So they were all along aware.
Yes.
So there's gross delay and negligence because this application, praying for setting aside, was filed on 16th of August 2019.
And the order was passed on
27/3/2018. Now, there is no explanation why the certified copy was applied in August. It was received on 16th of August itself. So then kindly also see their prayer.
So the order is 28/2, correct?
No, but it's the first order rejecting
the order
the
they're challenging is 28/2 in this.
No, both the orders. In their prayer, they're challenging 27/3/2018 as well as 6/9.
Yes.
Kindly see their prayer at page 26. So very deliberately and well designed, they blame the counsel. They allocate the entire blame on the counsel for laches on his part. And the prayer is towards the end, my lord. It is therefore prayed that the Honourable Court may be pleased to accept the petition by considering the causes of delay due to fault of earlier engaged advocate, medical suffering of the petitioner defendant, and long distance for communication. The petitioner defendant number 4 is also ready to deposit reasonable cost for accept her written statement. Hence, Your Honour may be pleased to set aside the ex parte order dated 27/3/2018 and may kindly accept the WS for ends of justice. So this is a complete misconception. There has been repeated delays on their part, and very deliberately they blame the counsel, whereas the court records in this impugned order that there was no latches on the part of the counsel, because the impugned order is at page 28. I apologize, not page 28, page 41.
Yes.
I'll just read the entire order. Lordships have it. CR put up today, Both the learned counsel of the parties are present. Seen and peruse the petition number 69 dated 16/8/2019, filed by the learned counsel Srimati Rupraj Ghatak for the petitioner Srimati Malati Prasad under 151, read with Section 5 of the Limitation Act, wherein the petitioner prays for setting aside the order dated 27/3/2018 and to condone the delay for filing of written statement and to admit the same. Seen also the written objection filed by the learned counsel A. Hussain for the plaintiff opposite party, heard both the parties. Learned counsel for the petitioner argues that previous engaged counsel, namely Samir Chakravarti, has informed the relatives of the present petitioner defendant of his withdrawal of Galatama from the instant suit, and that the said counsel did not made any prayer in writing for condonation of delay for more than 90 days, nor took any steps towards filing of WS. Learned counsel submits that on above said grounds, an order was passed to close the filing of WS on 27/3/2018. Learned counsel also argues that the petitioner defendant is an illiterate woman and having no legal knowledge, and being a permanent resident of Uttar Pradesh has no permanent shelter in this district, and that only upon learning about non-filing of WS the petitioner has promptly taken steps for setting aside the order dated 27/3, it should be 2018, and to accept the WS. Learned counsel further argues that on such default of previous counsel, it has caused a delay of 646 days beyond the statutory period as prescribed under the code. Learned counsel also submits that in other suit, that is TS number 5 of 2010, which is pending in this court, a delay of 570 days was condoned and WS was accepted as per order dated 10/12/2018. Learned counsel further argues that the petitioner was not able to submit her written statement within the requisite time frame, and on the ground that she was suffering from ailments and underwent treatment from 12/3/2019 to 7/7/2019. Learned counsel also made reference to the judgment held by Apex Court in Rafiq versus Monchiller and Nather. Medical certificates are enclosed and marked as annexures C, D, E, and on above submissions, petitioner prays for allowing this petition and to set aside the order dated 27/3/2018 and to accept WS. Learned counsel for the opposite party argues that several dates were fixed for submission of WS, and the learned counsel for the petitioner did not make any prayer for condonation of delay, although the statutory period under the code had elapsed. Learned counsel further argues that order dated 27/3/2018 was passed only after giving both sides an opportunity of hearing. It is submitted that as per the said order, the filing of WS was closed and date was fixed for taking evidence. Learned counsel also submitted that evidence on affidavit of plaintiff's witness number 1, 2, and 3 had already been submitted and that it is pending for cross-examination. Learned counsel argues that the court has, as per order dated 27/3/2018, made adverse observation against the defendant and that the said party lacks due diligence, and there was no exceptional circumstance to allow the filing of WS, and accordingly the court has closed the filing of WS. Learned counsel prays to reject the petition with heavy costs for ends of equity and justice. I have examined the medical certificate marked as Annexure C, wherein it was reflected that petitioner was found to be suffering from chronic viral hepatitis and anemia since 5/6/18 and is found to be fit from 6/8/18. I have also examined Annexure D and E. There is nothing in all the aforesaid annexures to show that the petitioners were prevented from taking steps or getting in touch with the said previous counsel. On above findings, the said annexures are not taken into account to consider this petition. I have also minutely examined the judgment held by Apex Court in Rafiq versus so-and-so. I find that the above said judgment has no bearing to this present facts and circumstance of the instant case. In the said judgment, the matter was decided mainly on the ground of inaction, deliberate omission, or misdemeanor of the advocate by absenting himself deliberately or intentionally. But in the instant case, the learned counsel was found regularly attending the court but has shown laxity to prefer an explanation and prayer to condone the delay to file WS on the date so fixed. The learned counsel also alludes to another judgment of Supreme Court in so-and-so. I have also perused the said judgment and find that the matter was deliberated only on condonation of delay of only 35 days in filing of WS and has no bearing in this instant petition where the facts and circumstances are completely different. Learned counsel also referred to judgment in so-and-so passed by the Guwahati High Court. I find that the above said judgment has no relevance in the present case at hand. The judgment was rendered in challenge to an order rejecting the petitioner to allow them to file additional documents and not for condonation of delay in filing WS. Learned counsel also referred to another judgment of the Guwahati High Court in so-and-so, but upon close scrutiny, it was also found to have suffered from same infirmity as it relates to an appeal for condonation of only 65 days in preferring the appeal. Learned counsel submits a decision of the Guwahati High Court in so-and-so. I have carefully examined the said judgment wherein the facts and circumstances of the case was different. The prayer for grant of time to file WS was made in the above said case, unlike the instant case where no such prayer was made for condonation of delay. This court, upon careful examination of the case, records, finds that counsel for the petitioner has shown to have been regularly attending the court. The petitioner has not given any satisfactory explanation why no step prior to this present petition was made. The petition also did not explain why it has preferred this petition after the delay of more than 1 year 6 months from the order dated 27/3/2018. The petitioner also did not show any exceptional circumstance in this incident petition for condonation of delay. I find that the entire matter shows that the petitioner was guilty of laches and negligence in filing the petition for setting aside the impugned order and thereby to allow filing of WS. In Salem Advocate Bar Association, it was held that the time can be extended only in exceptional hard cases. While extending time, it has to be borne in mind that the legislature has fixed the upper time limit of 90 days. The discretion of the court to extend the time shall not so frequently and routinely be exercised so as to nullify the period fixed by Order 8, Rule 1. Therefore, on consideration of the above rulings and so on, this court is inclined to reject the application. So there are two aspects, my lord. One, his entire case, as he admitted earlier, that 2017 he received notice, and on the day when he filed the WS, I did not raise an objection. That is incorrect. The order sheet speaks otherwise. That is one part of it. The other part is in 2009 itself, notice was issued. Yes, he said he had instructions from his client that they did not receive notice and he would file an affidavit to that effect. Because his oral submissions cannot be taken into account. Till date, no such application has come forward. No affidavit. So lordships will have to look at the records and see that from 2009, no steps have been taken whatsoever. Even the most recent application of 2019, there was a huge delay. They were in possession of the certified copies of the orders that they wanted to challenge, but they preferred it after 1.5 years, and the trial court has recorded that. There is no explanation even in this revision application, except the fact that she is illiterate and she resides in Uttar Pradesh. That is not sufficient. And whereas a party's right to file a written statement and its duty starts as soon as they receive summons.
My lord, my friend, he's saying that I have entered appearance, but he has not read the subsequent order, lordship.
1 second. Yes.
I'll just read out some orders. The summons should accompany the plain, lordship. There is nowhere in the order sheet which says that the defendant has received the plain.
One second. Yes. No, what do you think?
I'll come to the order at 31st/7/2009, where my friend is saying that I have entered my appearance, lordship. I'll just
here.
Yes, lordship.
11/5. Then. Okay.
I'll just read out, lordship.
Where is that?
This is page in 3, lordship, in the compilation, lordship.
31/7/2009.
Yes, lordship.
Plaintiff present and represented. Defendant number 2 and 4 presented by the lawyer.
Yes, lordship.
Then?
Case fixed 18/9/2009. 18/9/2009. And what happened to 18/9/2009? Now again, lordship, kindly see. This is fixed for what? Case adjourned due to other? Not late.
Administrative work.
Other.
Yes.
Then matter was supposed to be listed on 18/9/2009. Order sheet says 6/8/2009, lordship. JM transferred case withdrawn to my file and transferred to Sri So-and-so, Magistrate First Class for disposal. Then 11/8/2009, case received, share received and transfer from the learned ADM for disposal. Issue the notices to the plaintiff and the defendants. Fixed 21/9/2009, lordship. Now 31/9/2009. 21/9, there is no order, lordship.
21/9, there is an order, page 5.
There is an order, page 5.
Page 5. Then in between, lordship, 31st, yesterday, page 5. Then both plaintiff and the defendants absent in spite of receiving notices, hence refixed on so-and-so for steps. 14/12/2009, lordship. Both parties are absent, hence case adjourned, refixed on so-and-so. Then 21/2010, plaintiff and defendants are absent. Issue fresh.
Effectively, that means from 2009, after your case will be that now you might have been present 2009 on 31/7, correct?
Yes, Lordship.
But after that, when another magistrate on reissuance of notice, he never received
No,
anything.
no, Lordship.
So only 2017 when
Yes,
it
Lordship.
came out a picture.
Yes, Lordship. And in the order sheet, nowhere says that I have received the copy of the plan. Just issuing the summons, that cannot say that notice is complete, Lordship. The summons must accompany the copy of the plan.
And it's never recorded in the order sheet.
This is recorded, Lordship.
Plain that the copies been received, that the plain and annexures and everything received. Do they ever record in the order sheets?
In the Lordship, in the 17 orders they have mentioned. In the 17 order mentioned, and I have received, my counsel has received in the order sheet, Lordship, that I have received the so-and-so, so-and-so. And the plaintiff on 17 has handed over the copy of the plan, submitted the copy of the plan to the court. After that, I have received. From 2009 to 2017, the case was not proceeding, Lordship, only for issuance of service. Then there was an order, Lordship, saying that the plaintiff, the defendant was no longer residing in Mahendraganj. Then subsequently fresh notice was issued to UP, Lordship. Then in 2017 only, when I received the notice, then I engaged the council. The council have received the plan from the courts, then only, Lordship. Now what my friend is saying, Lordship, that I have objected. When he objected, Lordship, he ought to have objected when the court has granted time for filing the written statement, that is 6 February 2018, Lordship. I have entered November, Lordship. January and whole month of January remain closed, Lordship, because of the vacation. Where is the laxity? Where is the delay, Lordship, on my part? He should have objected on the day, that is, I'll just come to again, Lordship, that order 7/11/2017 onwards, Lordship. 7/11, I have entered my appearance.
7/11?
7/11/2017.
Okay.
I have entered my appearance and received the plan from the courts. That is recorded in the order sheets. That is page 40, Lordship.
So you say that you say that effectively that means the proceedings were recommenced from 11/5/2017.
Yes, Lordship.
That will be your case.
Yes, Lordship.
That effectively, so all that happened in 2009 and 11/5/2017 should be washed away.
Yes, Lordship.
As a non,
Yes, Lordship.
as a proceeding was zero.
Yes, Lordship. Had there been an order for filing a WS, what prevented the plaintiff to raise an objection for closing of the written statement? In the order sheet, nowhere says the matter is fixed for filing a WS, filing of WS. Now he could have objected, he could have filed an application saying that so many years has passed, so now the WS has been should have read for closing of the WS. But he did not make any attempt for closure of the WS. In fact, there was no order such for filing of the WS. The order reflects that SRN appearance, SRN appearance. Even the plaintiff also did not appear, Lordship. Even the after 17 also, Lordship, when he has engaged the counsel.
Okay, so you see from 11/5/17 when it was issued, then you
Yes.
effectively entered appearance on, where is that? That is on
17/11. I have entered appearance, Lordship.
17/11/2017.
7/11/2017, I have entered appearance. And I have received the copy of the plan.
That's page 40.
Page 40, Lordship.
And file a, see this one, CR put up, learned counsel so-and-so, President Court plaintiff and file the copies of the plain and relevant documents. This is important then.
Yes, Lordship.
Yes. Learned counsel S. Chakravarti present and file wakalat and is representing
Defendant number four.
Be it notified AGP, reissue notice to defendants 1, 2, and 3. Copies furnished to son of
Yes, Lordship.
Okay.
On 7/11/2017, copies was furnished to me, Lordship. Now the matter is fixed on.
1 second. Now after that, so
Lordship kindly see Lordship fixed 28/11/2017 for appearance of the defendant number 1, 2, 3 and steps.
on 28/11.
Yes, Lordship. For steps. Not for filing written statements.
So 2011 N. Sangma also is present. Fix 11 for filing of WS.
6/2.
6/2.
Now on 28.
On 6/2 you didn't file it.
I didn't file it.
Yes.
Now on 6/2, my friend should have
raised objection.
Raise objection.
See, 6/2, CR put up the counsel so present and file wakalat representing the plaintiff, learned counsel D.S. Sangma, GP present for 1, 2, and 3, Chakravarti present for number 4. Defendants have prayed for time to file WS.
Has he made it?
22, 20, and you file it on 28, correct? Is 27 or?
22.
The
Fixed
date
22?
fix was 27, but 27th was a holiday.
No,
so on the
22.
28th we filed it. So that is the day we raised the objection.
22, Lordship, date fixed.
Then, Mr. Sen, if that is correct, if the copies are furnished only on...
You know, Malus, just kindly appreciate this. He says his client is residing in UP. We don't know what transpired. The burden is on him to prove that they never received the plaint. It very well happens that we go to the court and we say, I'm entering appearance, I want an extra copy of the plaint. That does happen. The burden was him to show that he received summons, but he did not receive a copy of the plaint. There is no application anywhere on record. Entire burden is on him. Order 8 Rule 1 clearly says it is from the date of receipt of the summons.
No, Order 8 Rule 1 says that 30 days
from the date of receipt of
summons, you file it in statement. If not, then you file an application for outer limit of 90 days. Shall.
Yes.
But a shall also has been, now is not mandatory. It's directory, but you should put a proper application for filing written statement. Now your case is that they will receive summons in 2009, so forget about that also. If they received, if the effective date appearance was 7/11.
So that's
that
is the issue. That why should we take 2017 as the effective date? It should be from 2009. There's everything on record to indicate that 2009 they had already received summons, which is why my friend said that he has instructions from his client.
One aspect consideration is that time it was not separated judiciary, and the court, it was re-endorsed another court, and as is done again, reissuance of notices and all. Whether reissuance of notices will amount to reissuance of summons or just...
I understand, Lord.
Or
In my humble
you
submission,
understand, only for appearance. You understand? Because sometimes when it goes to the court, the reissue notice doesn't necessarily mean that it's summons.
Accompanied by...
It's not. No, Mr. Shea doesn't necessarily mean that it's the first time that you've been issued summons.
Yes.
Correct.
Summons were received. Your case goes to limbo. Happened many times here also.
True.
Absence of presiding officer, your case goes to limbo. But then when a presiding officer is appointed to preside over that particular court, then notices are issued again. Like now the court's functioning, you come back, and so it should start from where it stopped earlier on.
Yes.
But that is what his case
and it's
is.
only a notice of appearance, my lord. It's not again a P5 form with a
We
plaint.
understand that. That should be taken notice of appearance. But you're saying that we never served. That is why last time the court said you put it on that you never served.
My instruction, Lordship, she now 1.5 decade, 15 years back, Lordship. 15 years back, she can't recollect, and she's an illiterate lady, and
No,
she
my
put
lord,
her
on
thumb
record he has
impression.
said that she did not receive. Today he says she can't recollect.
No, when I asked her for filing the affidavit, Lordship.
No, these are two different things. On the first day, after Lordships had confronted him with that order, he said he came back with instructions and he said she'd never received notice.
My lord, even assuming, for the sake of argument, Lordship, that she has received the summons on 19, Lordship. 2009. Is there any order passed by the court? The matter is fixed for filing of written statement? No. The matter is fixed for steps and appearance. Now, had there been an order, even though there is an order, have the plaintiff made any submission before the court saying that the
Now burdens on whom?
burden on the plaintiff, he should have made a prayer.
No, burdens on you. Now, if you see summons of burdens on you, you can't file a statement within
Unless-
certain
unless
time, and you write the reasons that principle could be filed due to reasons 1, 2, 3, and 4, and the court consider.
My lord will.
So you want to say that it is burdens on him to say that close of filing written statement by you.
My lord.
And then you will come to application that time to say, okay, fine, consider for extension of time.
My lord, why I am saying in between 2009 to 2017, lordship, even the whereabouts of the plaintiff was not recorded, lordship. She also did not enter her appearance, lordship. Now, if there is an order saying that file a written statement, and after that, if I fail to file the written statement, then the court has every liberty to close my written statement, lordship, unless there is an order.
See, but court has, in a manner, though no objections were raised, court has taken up and said we can't accept written statement. Correct?
Yes.
This is one more aspect. This had escaped my attention.
Now,
issues were framed. In fact, parties participated in the framing of issues. Kindly see page 57 of the order sheet. So after the first order, whereby his written statement was rejected, page 57, there's an order dated 2/8/2018. C.R. Putta Patel, Learned Counsel A. Hussain, representing the plaintiff, is present. All the defendants are absent. Seen and peruse the suggested issues filed by both plaintiff and the defendant.
Okay.
Issues were framed. Matter is proceeded to examination of witnesses. It's at the stage of evidence. They don't participate in that as well. So the intention is to try and drag this litigation.
No, lordship. If we see the first input letter where I have repeatedly asked for time for filing the written statement, no. And it is not that court is powerless to enlarge the time. Court has the power.
You amended your plaint also?
Yes. There was a mistake in the date as indicated. Instead of 01, it should have been 10. That was the minor amendment that was done.
And my lord, this is the pensionary benefits I am receiving. This is a case with regard to the pension, lordship, because the plaintiff has filed a case seeking a declaration that I am not the wife of the late
It's only for
Gyani
that.
Ram.
I thought for property. It's
No,
not for...
this is a pension, lordship. And the WS is my foundation, lordship. Unless I...
Even you don't file a release, it doesn't mean that you're precluded from taking part in the proceedings.
Obviously, lordship, WS is my foundation, lordship. My entire case will lie on my WS, lordship.
Because I have just one judgment on this issue. Date of summons, receipt of summons becomes the
We understand,
active
but
date.
the only thing is that you see one thing, Mr. Sen, is that which is troubled in the mind of the court is that taking into account like the fluid situation we had before separation and all. Like suppose it was a clear-cut case for proceedings going on day to day or whatever. Like it's a regular court and it's a bit separated. Then we can take a very a stringent view with regard to non-filing statement and whether any steps were taken by the defendant to seek time for extension, so on and so forth. But that's the only thing.
To be very honest, when I first went through the entire application, I thought there's no reason for the court not to allow. But after going through the order sheet, the story is a little different.
No, the story is a little different, but...
So I would only request Manoj to go through the conduct of the parties to see if there was any deliberate omission on their part or not. In my humble submission, after going through the order sheet and also the delay...
What judgment you had?
This is a judgment of 2018 6 SCC 639. Adcom Technologies. Lordship will have to just go through the facts of this case once. 2018 6 SCC 639. Lordship will leisurely just go through the facts. There's a long list of facts in this. From para 9 onwards.
So we'll balance equities, you pay cost.
Lordship, whatever my lords.
How old is the defendant now?
She will be nearing 50, lordship. No, not
Only
60,
50?
60, 60, lordship.
Now it's gone up by 10 years. From para? From para?
Para, para 9 onwards. What is the age? Isn't the age mentioned? What is her age? Some blank.
See, you come to para 16, the submissions. See, it's like your submissions only. That
Well, it's para
16.
So the dispute here is whether summons was served in 2009 or 2000, in the year 2000. Plaintiffs claimed it was served in 2000, and the defendants claimed it was served in 2009. And the court found that it was actually served in the year 2000.
So
my friend's case here is that it should be recorded from the date of reissuance of summons in 2017 onwards.
He's maintaining that effective date is 17/11/17.
2017, well,
Correct?
Yes, Lordship. 7/11 to
For you, the game started in 17/11/17.
17.
Well, that's
Whatever
because-
happened before was washed away.
So that's because he decided to elect that date.
That's not acceptable, Mr. Sheikh.
No, my
Because
lord,
it's not reissuance of summons, it is just notice.
I am not saying, Lordship, to that effect, Lordship, if I may be allowed to read one judgment of this Honourable Court, that Mittal judgment, Lordship, para 25, Lordship.
Read it.
Para 25, and here, Lordship, a look at the order passed by the learned trial court shows that there was never any direction about filing of written statement by opposite party defendant, whereas direction were given only for filing of show cause by them in so and so.
Where direction? If the statute provides such,
yes, Lordship. Now,
is this after receipt of summons in 30 days is incumbent upon you to file a
now
statement?
not only the summon should accompany the copy of the plain, Lordship.
But where is that?
Now you make a new case that at a time when summons issued, like when you appeared on that date, you not given copies of the plaint.
That is for the sake of argument, Lordship. That is why I am saying, even if my friend is saying that I have received the summons, Lordship, that on 2009, then I am barred to file the written statement. For the sake of argument, I said earlier also, even I have received, Lordship, but mere serving of summons without the plaint, it cannot be said.
How can we ascertain that whether you given copies of the plaint or not?
Lordship,
You have to look in the sheet whether you received or not.
So, Lordship,
Your endorsements.
That's a different issue. He should have taken that plea. He never took that plea in his revision application. He was given an opportunity to file an affidavit.
Then pass orders.
Highly obliged.
Highly obliged.
Heard judgment reserved. Yes.
17. 17.
It's settled.
No, but it's nothing much has come about it.
Mr. Chakravarti has been dozing on and off for the past. No, that's perfectly all right. Seniors are just,
Sorry, Mulad.
But civil matters for the audience here is very boring. Correct. But we have to do it, Yes.
Here, Mulad, of course, on the last day, the point was raised that
It's a clear-out matter, correct? Where cost, you only agree with the cost.
cost and Mulad, the petition has been dismissed. Petition for reference to arbitration. So if a petition has been dismissed, Mulad, that means here the the applicant, the petitioner, would be debarred from raising the issue again. So, Milord, in my humble submission, Milord, this whole order needs to be set aside.
Yes.
And after that, if your Lordship is pleased, the matter can be referred back for appropriate steps, whatever. Whether they will pursue in the same court or they will go to the... The matter is in the court of the superior court only, in the court of the additional deputy commissioner. So if this order is set aside, then the matter goes back to the court of the additional deputy commissioner only. I mean, ADC, additional deputy commissioner. Now the suit is before the assistant, but this application for reference to arbitration, this was decided by the court of the additional deputy commissioner adversely. And when it is decided adversely by the additional deputy commissioner, if that order is set aside, it goes back to that superior court. And thereafter, Milord, whatever is to be decided there. I would say that there should...
You mean to say that this court of the, district judge, whatever, decided on the point of jurisdiction?
Yes. Only on the point of jurisdiction, saying that, my lords, the suit is pending before the assistant to deputy commissioner. So, Section 8 application would lie before the assistant to deputy commissioner and not before the additional deputy commissioner.
And it's recorded you file a written statement before the additional DC instead of filing in the court of
assistant to DC.
So that is the whole case, my lord. What was the circumstances?
Section 8 in any case would lie before the assistant to DC. My lords, before my learned senior starts on the facts of the case. Now, the grievance of the petitioner seems to be, my lords, they say there is an arbitration clause, let the parties be relegated to arbitration. We do not dispute it. Now, what I had submitted before lordships is, my lords, that the entire purpose of sending the matter back and then again an arbitration, they filing an application or either way, an arbitrator being appointed was unnecessarily going to delay the matter. The matter has been substantially delayed in any event.
Yes.
What would have been proper is, my lords, that some arbitrators can be appointed by your lordships and the matter can then proceed. That would be
agreeable.
Milord, we had tried, Milord. There was an observation by your lordship also in an earlier order.
With regard to
that the parties are given, we are given the opportunity of suggesting some arbitrators. Because under the arbitration agreement, we are the ones who would be appointing the arbitrator. But that observation was there, that observation was communicated also, but we didn't get any response from the...
Then the court will appoint.
Milord, that if you're... Milord, that aspect is there, but I would still submit, Milord, because this issue, whether the matter has to be at all referred to arbitration or not, as per the petition.
As per the petition meaning?
They say, my lords, somebody is to be appointed. There's an arbitration clause, arbitrator is to be appointed.
Yes.
Your lordships are aware, after the new amendment, the option of either party, my lords, appointing an arbitrator, in-house arbitrator has been done away with.
Yes.
So the scheme of the act has changed, so it has to be somebody who's an independent arbitrator,
Yes.
essentially somebody, and considering the stakes, it would be somebody who would be preferably a retired honorable judge of the High Court. I had suggested to my learned senior, my lords, certain names. So if they can take instructions, this matter can be put to rest.
Justice.
That I don't know whether...
At least you can expect speedy disposal.
This amendment which my friend is referring to.
No, he's come out of via media, that's all.
Sorry,
He's come out of via media, leaving all these things to cut short the entire, the going back and coming around, circumnavigating the courts, getting orders, getting hearings, and finally coming to what you want. That is appointment arbitrator to, whatever. Because even arbitration clause is there, the court's duty and fact only to, order of arbitration. Actually, it's limited only to that. And the umpteen judgments that say that only.
Milord, if your lordship, on that point that the law has been changed, law has been amended, if since my friend has, a submission has come to that effect.
You kindly take instructions within 2 days. We'll have it on Wednesday, and then just come. Whether you're agreeable, then we'll pass orders accordingly. We'll set aside the order also. Because it's just mired in the jurisdiction aspect, which this court seems
Because
has taken grave offence to the matter being put before the additional deputy commissioner. That is
So what had happened actually, my lords, in this matter is when this application was initially filed, and when we filed an objection, we pointed out that the suit is pending before some other court. Now, what is not what is not on record is the court had made an observation that if the suit is pending before some other court, Section 8 lies there.
Yes.
So you
pursue it there.
You either pursue it there or we will transfer it from here to there.
Court should have transferred. Court should have endorsed.
So
when the main
what happened is that there was insistence on the part of the petitioner that this court has the jurisdiction and you hear the matter. That is the argument. Your lordships would have seen that is the argument made. So that is why probably that cost came. We're not really on the cost. There's nothing on the cost issue. But otherwise, also, my lords, I would humbly submit that if the order of the learned trial court has come on the basis of, my lords, only on the issue of jurisdiction, that would not act as an res judicata for them to file a fresh application before an appropriate court. That would not be a bar. Because it's only on the issue.
I mean, they have to have remedy.
Well, because that would not be a bar insofar as Section 8 is concerned. It would lie before the appropriate court. But the other aspect is now they also filed a written statement. So in one court you file a written statement, one court you file a Section 8.
Well, if I can take your lordship, when the application was filed, my lord, at that time there was no endorsement to the lower court. It was in the court of the additional deputy commissioner.
I understand. So you're ignorant about the local, the local administrative of justice aspect. That's why you were like pursuing the matter in one court. That will be it happens to many people, even lawyers also. Yes.
It was already, I mean, the matter was at that time in the court of the additional deputy commissioner also. And this is also before separation of judiciary. When the application was filed.
Before separation?
Before separation.
The suit was filed before separation, my lords.
Suit was filed
Suit
before
was
separation.
filed before separation. Application came after separation.
Okay.
Application for
after separation.
I'm not very sure,
Just-
but
just-
suit was filed
Just
when
before separation, my lords, the suit was filed. Then the application.
Let it
came
come up
subsequent.
let it come on Wednesday. You kindly come up with a concrete
Wednesday
thing.
next, my lords.
We'll just this Wednesday next. This will be on 28th. We'll settle it.
28th.
And this is a matter of fixed item on 28th.
Also, if my learned senior can take, let's
Instruction to the arbitrator. If we're agreeable, cut it short. If law permits, yes.
Actually, that would be, of the records, I think I agree with my friend. That will take what is the point of going back to the...
See, going back, if you're going to raise point on arbitral disputes,
But here,
because has been held, you see that an arbitral tribunal is, the most preferred, in these kind of disputes, most preferred, in the first instance. That will settle it.
My whole problem is that earlier, in spite of your lordship's observation, till now I have not received any cooperation. I'll try again.
No, you'll receive cooperation now.
I'll try again.
Not cooperation from this side, but it's cooperation from elsewhere. I must put it very quickly.
Yes.
Obliged.
Obliged.
It's a fixed matter, yes.
On 28th minute.
28th.
Item 18.
Obliged.
Item 18. Mr. Hazarika.
Where's the affidavit?
Affidavit has been filed, my lord.
You received copy?
Yes, Your Lordship.
My lord, Mr. Hazarika is... My lord, we'll give them a copy. We'll give them a copy, my lord.
Yes.
He's asking for you, sir.
Where's that affidavit? So who's the science teachers of the school? You're not there.
I
Your
am
name's
very
not
much.
there.
I'm very much there, Your Lordship.
Then?
And I'll prove that during the hearing, Your Lordship. I'm very much there. I'm very much a sanctioned teacher, Your Lordship.
It's contradict.
My lord, in para 3 of the new affidavit has been stated.
Yes. They say that you see that Norbert Marwin, IT Hun Shangpliang and Shidan Line Lingdo Maulot, approved sanctioned teachers. When the selection held?
23rd March 2010. That is the date of interview. And petitioner also, she applied for the post also. If you look at our affidavit, page number 18.
One second.
Affidavit of respondent number 5.
So approval was given on 1
Your Lordship,
Yes.
Your Lordship, if you turn to my petition, page number 33, everything will be clear, Your Lordship.
But if these clear facts have come from the government that you're not a sanctioned teacher.
Yes, Your Lordship. Even in page 33, the letter has sent by the secretary to the district mission coordinator, Your Honor. And there the fact is something else.
Where's Mr. Hazarika?
Well, he's gone out of station today.
What do you got out of station today? Page?
He's gone to government.
Page 33 of the main petition, Your Lordship. Starting from point number 2.
This is from the school.
Yes, Your Lordship. So the fact will be very much clear by just going through page 33, Your Lordship. Main petition.
Oh, I understand. So you are there as a teacher, but not as a sanctioned teacher.
Your Lordship, I am very much a sanctioned teacher, Your Lordship.
Then, because what they usually do in the schools is that you have 3 sanctioned posts, they appoint 4 teachers, and you share the salary.
No, Your Lordship, the sanctioned posts were 4. September 2017, they have reduced to 3. And just because I was not happy with the decision, my name was removed. And here nowhere is mentioned that I'm a
And then Ms. Hazarika, come with this. You have given copy of the affidavit to, advance copy you've given to her and to other respondents.
We'll give them a copy, ma'am.
Yes, sir. When will he be available? Next week? Just a matter after 1 week as learned GA is not available presently.
Your Lordship, I pray if it can be fixed a short date because my petitioner,
1
she
week.
have got 5 minor
1 week.
children in
22.
school and everything, Your Lordship. So
22.
good day, Lordship.
It's of one arbitrator.
Your Lordship,
Or section 30, what does this matter?
this is appointment of the arbitrator, wherein the petitioner is seeking second arbitration.
Both of you are agree with the award?
Both of us, we were agreed with the award, and both of us filed section 34 applications.
Yes.
On the date of hearing, my learned friend has come up that this award may not be sustainable.
Yes.
And therefore, in view of the fact that my section 16 application was not decided.
Was not?
Was not decided.
Okay.
And therefore, the award becomes defective and cannot be enforced.
Yes.
Now, I'll just take to your Lordship the order
This was
come to page 26.
Page?
Page 26 onward. I read paragraph 2 at page 29. The parties have exchanged the pleading. As such, this application has come up for final hearing. Learned Senior Counsel V.K. Jindal, assisted by E. Marvin, present for petitioner applicant. Learned Counsel for the respondent, Shri George Thomas, Shri Sarup George, Shri R. Groom, and Srimati A. Sangma present. Conventionally, the argument is commenced by the applicant, that is me. However, in the instant case, the learned counsel for the respondent has initiated the hearing of proceeding by making a fair submission that the impugned award does not pass the test of statutory requirement under Section 34 of the Act 1996. As such, it is not sustainable. It is the submission of the other side. They say that award is not sustainable. And conventionally, I would have started, but he took up, he said that there is no point of arguing because award is not sustainable.
Okay. Yeah.
Then paragraph 6, this court finds that it will be necessary to examine the records and pleadings of the party in as much as the award passed by an arbitrator cannot be set aside merely on asking or by the consent of the parties. Your Lordship will mark this thing. That court view, that somebody says that set aside the award and I will set aside the award, no, that is not done. Under backdrop of the submission made by the learned counsel for the respondent, records are examined. Then, Your Lordship, I take to paragraph 10. The learned tribunal, while passing the impugned award dated 18/1/20, did not decide the issue number 2 and 3 and disposed of the claim of the respondent while the impugned award. Learned senior counsel impressed upon this court that the impugned award does not only suffer from devoid of finding on issue number 2 and 3 by the learned tribunal, the application filed under section 16 of the Act remains undecided. Then, Your Lordship, I take to paragraph 13 at page 34. At page 34, without referring to any decision to fortify its conclusion, finds that the impugned award suffer from violation of principle of natural justice. The applicant has been deprived of the opportunity of being heard. As such, he was not given fair opportunity to present his case. The impugned award dated 8/1/2020 was passed in breach of section 18 of the Act. As such, it suffer from the infirmity under subsection so and so of section 34 of the Act 1996 and liable to be quashed. This court at the recital had mentioned that the respondent has not registered or defended the legality of the impugned award on the above mentioned ground. This paragraph, Your Lordship, will say that court has looked into the everything and came to this finding. And these findings are findings on merit. Then, Your Lordship, I take to paragraph 17. The learned counsel for the respondent prays before this court that the respondent may be given liberty to take appropriate action in accordance with law and has placed some authority before this court to substantiate his argument. This court finds that the respondent is entitled to equitable relief for his assistance rendered to this court. The prayer of the respondent does not run contrary to the contract, nor there is any statutory bar. The respondent is at liberty to take appropriate action in accordance with law. Needless to say, the benefit of Section 43 of the Arbitration and Conciliation Act 1996 will be available to the respondent in the event of the respondent seeks remedy under the law. Your Lordship, based upon this observation, my learned friend's case is this, that court has given us the liberty to take recourse to Section 43. Now the question which arises here, whether Section 43 confers any right to have a second reference.
The 43 is limitation.
That is limitation. I'll just come to that, Your Lordship. Yes. Now, there is no dispute that claims which were referred to the earlier arbitration are the same which are thought to be again referred to the another tribunal. The basis of his right, he has to establish some right, that on what basis he is seeking for a fresh or de novo trial of the entire matter. He falls upon Section 43. Now, Section 43, Your Lordship, Clause 4. Clause 4. Where the court orders that an arbitral award be set aside, the period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the time prescribed by the Limitation Act 1963 for the commencement of the proceeding, including arbitration, with respect to the dispute so submitted. So, this is relied by my learned friend, and this is what is stated in the judgment that he will be entitled for the benefit of Section 43, that is 4. Yes. My submission, Your Lordship, is this. Subsection 4 of Section 43 confers only a right towards the limitation. It does not give any authority to have or ask for the second reference. There is nothing mentioned here. Section 43(4) cannot be extended to such an extent which confers right of having a second reference. Your Lordship, I'll come to the case law a little while. First, Your Lordship, let me point out with a recent judgment of this Honorable Court, (2023) 8 SEC. Just a minute. 2023, very latest judgment.
Yes.
8 SEC 50.
Yeah.
50. Your Lordship, I read paragraph 10. What the court must do on the application under section 11, and what the reference court should do or should not do. Paragraph 10, Your Lordship. At this stage, it is required to be noted that as per the settled position of law, pre-referral jurisdiction of the court under section 11.6 of the Arbitration Act is very narrow and inheres two inquiries. The primary inquiry is about the existence and the validity of an arbitration agreement, which also includes an inquiry as to the parties to the agreement and the applicant's privity to the said agreement. The said matter requires a thorough examination by the referral court. The secondary inquiry that may arise at the reference stage itself is with respect to the non-arbitrability of the disputes. Both are different and distinct. There are twofold inquiries, Lordship. I would like to also...
So you're relying on the secondary one?
No, I'm relying on first and second both. I'll show you, Lordship, that the agreement clause which is referring to, it comes to an end with respect to those claims which are already referred and decided by the arbitral tribunal. That will take away from the arbitration clause.
So you say they're not arbitrable anymore?
They are not arbitrable anymore.
Okay.
Paragraph 2. However, so far the dispute with respect to the existence and validity of an arbitration agreement is concerned, and when the same is raised at a pre-referral stage, the referral court has to decide the said issue conclusively and finally, and should not leave the said issue to be determined by the arbitral tribunal. The reason is that the issue with respect to the existence and validity of an arbitration agreement goes to the root of the matter. So, Lordship, here, there is no dispute that
Vidya Drolia is the leading judgment.
Pardon, sir?
This Vidya Drolia, this 20.
Yes, they have referred, Your Lordship. That's why there are other two judgments also, DLF, and that is also referred here. So 2023 is the latest judgment. And thereafter, I suppose one judgment of Chief Justice also has come, but same principles.
Which Chief Justice?
Chandrachud. He has also given one judgment, and that is reported in, I think, volume 8. But it is on the same line.
So, but the 11.6 now, there's another judgment also, if I'm not mistaken, passed by this, I don't know, in November or something, I'd come across with regard to 11.6 only.
11.6 year order after amendment.
Yes.
After amendment of 2019, the scope is reverted back what it was prior to the 2015 amendment, prior to 2015. Now only two areas are left out where this court has to look into. First, about the existence of the arbitration agreement. So far this part is concerned, my submission is this, that arbitration agreement is there, no doubt. But it has come to an end in respect of those disputes or claim which are already referred. Now, second reference.
Can arbitral tribunal take that up as a question also?
No, this question arbitral tribunal cannot take, because this is again a question of jurisdictions. This cannot be left to be decided by the arbitral tribunal. Only second question relating to the non-arbitrability, and that also Your Lordship will have to say something, that this requires elaborate inquiry which cannot be done on an application under section 11.6. So, first one, I have taken the plea that after this reference is already made, supposing the reference itself was defective, there is no case that the reference is defective. The second reference is possible if the first reference is defective. But first reference is not defective. Arbitral tribunal is constituted.
But did you raise those points with the commercial court?
Which one?
These points you're arguing now.
Yes.
It is there in the commercial court judgment.
No, 11.6, Your Honor, there was no necessity to place those things because 11.6, the commercial court is not confronted. Because he came with a predetermined mind that set aside the award. Because there was a reason. The awards which have come, there is clear finding that he is not entitled of any claim. Only on the basis of equity, the tribunal has given something, 50% of the awarded amount. Otherwise, the tribunal has come to the definite finding that contractor is not entitled to. What was the main dispute, Your Lordship, before the arbitrator? That there is a quantity variation clause. In every contract, Your Lordship will find that there are two important clauses. One is quantity verification and quantity variation clause. Second one, price escalation clause. Now, there was a quantity variation clause. Now, quantity variation clause says that supposing the contract value is 100 rupees, and if it goes to 125 quantity, say I have given a contract of 100 rupees, and if the quantity goes up to rupees 125, there is no increase in the payment. But if the value goes more than 125, it reaches up to 130, then his case is that he is entitled for enhanced value from rupees 101 to 130. Whereas the contract provides that up to 125 there is no increase.
Okay.
No increase. That was the clause which was the bone of contention before the learned arbitral tribunal. Tribunal referred to the judgment of the Supreme Court, wherein it was explained and came to the finding that the interpretation placed by the contractor is not tenable, and they have held that increase will be only after 125, not from 101. Not from 101. Now, he is aware because that finding cannot be set aside, Your Lordship, because it is based upon reasoning. And
so you are saying that they are asking for
yes, Your Lordship,
appreciation
of
this entire arrangement.
Entire matter. And
so you're saying that comes outside, it's non-arbitrable any longer.
So
that can be sent to reference again.
That cannot.
So are you agreeable in the other areas which can be sent to reference?
For other claims, it can be.
Then, so that means only on the arbitrability of these two. I mean, what one or two claims. That's the only thing that you're concerned about.
Yes, which was the subject matter of the arbitration in the first reference.
But the commercial court set aside the entire award.
Commercial court set aside the entire award, and Your Lordship, this jurisdiction question, Your Lordship, it was so far the jurisdiction on limitation under Article 137 is concerned. There is a finding of the tribunal that the claims are not barred by limitation under Section 137. Other area of limitation was this, that there is internal mechanism provided in the arbitration agreement that a decision is given by site engineer.
So now where are the proceedings? I mean, is the award annexed here?
Which one, sir?
The award's annexed here.
Award.
We can, this.
I think he has not done it. Award. I think that.
Your arbiter is not here.
No, it is there, Lordship. Your Lordship will come to page 59.
Which part is, you see, is non-arbitral any longer, and which part can be referred again?
No, yes, sir. Your Lordship, entire claim, whatever is decided under the first reference.
So you see in the entire claim there's nothing arbitrable any longer?
No longer. Because a finality has come.
That's difficult to swallow.
Your Lordship, definitely, if it is difficult
you can't shortcut the claims.
No, rights. Your Lordship, there has to be something. Now, let me go a little further, Your Lordship. That I take to Your Lordship, if Your Lordship take 1940 Act, 1940 Arbitration Act, which is Arbitration Act, Your Lordship will take Section 37, subsection 5, which is perimeteria same with 43(4). No, in this arbitration, in this Arbitration Act 1940, 37(5).
Or 37(5). Yes.
Lordship got it. Where the court orders that an award be set aside or orders after the commencement of an arbitration that the arbitration agreement shall cease to have effect with respect to the difference referred, the period between the commencement of the arbitration and the date of the court of date of the order of the court shall be excluded in computing the time prescribed by Indian Limitation Act 1908 for the commencement of the proceeding, including arbitration with respect to the difference referred here. Now, this provision is perimeteria same with Section 43(4), which I have already read. Now, I'll refer to two judgments. One is from Calcutta High Court.
So, Mr. Jindal, you're going to short-circuit the whole process and kill all the claims of the petitioner by pressing this case. That, notwithstanding anything else, nothing remains for arbitration.
So far, these claims are concerned.
Yes.
So far, these claims are concerned.
Claims remain?
If he has got other claims, other than these 7 claims.
So 7 claims, you say they are dead now?
They are dead now.
They're dead.
They are dead now. Only the thing what he can do,
is
that challenge the order of the commercial court on a Section 37, and he can get the case remanded that for other claims.
Yes.
Your Lordship will...
Because you know the limitation on the 11.6. Now, the thing is
11.6,
that-
Your Lordship, I have already pointed out that there are only 2 areas.
Exactly, 2 areas, yes.
And I am on both. I am on both. First, in the sense that my case is this, that
the first condition has been because there have been arbitrable, there's an arbitrable dispute that's already been done.
This has,
That's already been
and for
answered
those
and
claims,
numbered, yes.
for
And
those claims, that arbitration
it's already over.
Is already over.
Yes, and number 2?
Number 2, it is
Which
not
is-
it is not arbitrable.
Not arbitrable.
For the reasons which I will be pointing out to Your Lordship now. Now,
so now on the first 11.6 is confined to that. Whether this, actually 11.6 is more constricted. Is that when you look at it, whether in the GCC or whatever in the terms of whether an arbitration agreement exists. Now, your case, like usually courts stop there only. If an arbitration agreement exists, we don't have jurisdiction to it because arbitral tribunal is the best forum to settle disputes. Now you're saying that is gone.
Gone.
That part 11.6 is gone because arbitration that agreement existed, that clause, and then that's been already been satisfied.
yes.
Satisfied by the
Your
settlement of
Lordship,
7 claims.
Your Lordship.
And an award has been set aside also.
I also do not say that there cannot be any second reference.
Exactly.
There can be second reference, but it must be provided either in the agreement or in the arbitration clause. If it is provided, and there are agreement, Your Lordship, arbitration.
Where is it provided?
Where it is provided.
You show me samples.
NAPCO does not have this type of provisions,
Then?
but in many cases.
Then you are governed by your own recitals of your own agreement. How can
Yes,
you import
definitely.
a recital
No,
which is
no,
another
that's what I'm
agreement which allows
no,
second?
That's why Your Lordship.
Which prohibits or allows
No,
second reference?
Lordship, that's why Your Lordship, I am telling that there is no such provision.
Which allows?
Which allows. Which
Then
allows.
maybe you are traversing into another area of arbitration law.
No, because the decision of this court on this application will never put an end to the arbitrations. If a award is set aside under Section 34, then everybody will ask for second reference.
So you're saying that the petitioner account 11.6, nothing will be coming out from this application for them.
Yes.
That is your case.
That's my case.
11.6, court's hands are tied also.
Court's hands are tight, and court is bound
cannot explore beyond that.
Beyond that,
Because two considerations.
and the court is bound to decide that issue if it is.
I mean, court cannot go beyond 2 considerations. That's it.
I could
Those
follow.
2 considerations. That's
Two
all.
consideration. That is that the either arbitration agreement should provide, or agreement should provide that there can be a second reference.
I think this is going to be a very long hearing if you're going to satisfy the court also. And the court also has to learn also. I mean, you're propounding entirely at least a new dimension into 11.6.
Because my friend has given me an opportunity to do so.
Yes. Right. We'll continue at 2 o'clock with Mr. Thomas. Huh?
I will take a little more time. If
2
you
days.
If you can do it tomorrow, Your Lordship. Continue tomorrow.
Because you see, very interesting point, but then your point also, it's,
No, whether Your Lordship.
the thing is that before the commercial court, they have considered that fine, that what suffers from this kind of information and defects, it cannot be,
And,
it's
Your
unsustainable.
Lordship,
And so for them, in
order.
fact, for them, the whole idea and before commercial court was that clean slate. Clean slate, that means let's go back for second referral, all issues. Now, you're coming with that, no, it's not a clean slate, it's something's already written that slate, that should take
Yes,
consideration, that's not arbitrable anymore.
After setting aside the award, what the commercial court has done, commercial court said that you are entitled to the benefit of Section
43 is nothing.
for whatever
Section 43 is
you have.
only after the award has been set aside and for new proceedings. So that's the only thing. That's benefit. That means that should not be barred by
That, Your
limitation.
Lordship-
That limitation aspect will not be a bar to them for instituting fresh proceedings.
Yes.
That's all.
That's all.
That's it. Yes. Now,
It's
but you
it's
raise a
confined
ground
only
that
to
now
that
you raise a
aspect.
ground here now that that 11.6 applicant 11.6 now
Yes.
they are no more arbitrable issues. Number one,
Yes.
and you're coming secondary issue now.
Yes.
Anyway, this is I have.
Lordship, I have given 80 judgments, including Supreme Court judgment on the same point. Same point.
Simple. For you, it is simple.
Yes.
For us, it is not simple. We are sitting at a small place.
No, your point is very complicated.
No place is small.
Place is small, but the issue is big.
No, I understand you. This issue is big.
It's a learning experience for the court also because anyway. When you want further hearing? Tomorrow?
Tomorrow. Because it will come in the supplementary list, so I'll do it.
Yes, this is a matter for further hearing tomorrow. Other matters take up at 2 o'clock or 2:15? Unless other matters, no, any short matters, no.
EPS.
2:15 other matters. Yes.
23.
Your one item we have 23.
He's ready.
No. Let it be next week, week after 23.
23. Other matters are 2:15. That nectar matter, he will conclude it today.
I would like to mention one item, Your Lordship, regarding item number 26. I pray for time, Your Lordship, because my senior is out of station.
Who's name, Mr. Nath?
El Kyangte.
26. What's your name?
Ilau.
26 is compare Tongper.
Yes, Your Lordship.
Okay, for 2 weeks, yes, 26.
My lord, in fact, two matters are lined up, my lord. One is nectar and one is that customs. Laltan Pui.
2:15. Yes, contempt.
Customs
Or customs.
matter, my lord.
What matter customs?
That Bitil Nat.
Who's appearing other side?
Mr. Dasgupta is. This is a short matter otherwise.
My lord, I have submitted my affidavit in opposition in compliance with your order, last order.
Amount, how much?
The exact amount.
So give them exact amount.
On 5/2/2024, I have given this affidavit in opposition.
I feel
At page 6 and 7.
Then we'll hear at 2:15.
Much obliged.